the American Civil War, a conflict that pitted brother against brother, redefined the boundaries of human endurance, and tested the fabric of American democracy, often remembered as a fight to preserve the Union to a large extent. It was also a struggle to reconcile competing notions of freedom, sovereignty, and the rule of law. Today we're going to discuss some of the legal paradoxes and constitutional questions that defined the Civil War. But when Southern states seceded, they did so under the banner of states' rights. When the secession crisis hit in 1861, the Union, under President Abraham Lincoln, initially approached the conflict not as a crusade against slavery, but as a response to disunion and rebellion. Lincoln was aware of the moral dimensions of the conflict, but in his first inaugural address in 1861, this leads us to our next paradox: African American enlistment without citizenship. In the aftermath of the Emancipation Proclamation, the Union Army recruited and enlisted approximately 180,000 African American soldiers. After the Civil War, the United States grappled with the question of how to integrate formerly enslaved people into a nation founded on principles of freedom and equality. The promise of equal protection and due process enshrined in the 14th Amendment faced persistent legal and extra-legal challenges, particularly in the form of black codes, segregation laws, and violent suppression. It took decades of struggle and the emergence of new legal doctrines to realize the full potential of these amendments. Landmark decisions like Brown v. Board of Education in 1954 began to dismantle the legal structures of racial segregation. However, the legacy of these constitutional paradoxes continues to resonate. The Civil War and Reconstruction Amendments stand as a testament to the complexities of American constitutionalism and the constant need to strive for a more perfect union. The result was the passage of the 13th, 14th, and 15th Amendments, collectively known as the Reconstruction Amendments. The 13th Amendment abolished slavery except as punishment for a crime. The 14th Amendment granted birthright citizenship and guaranteed equal protection of the laws. And the 15th Amendment prohibited denying the right to vote based on race. Together, these amendments legally dismantled the foundations of slavery and Jim Crow, enshrining the ideal of universal male suffrage regardless of race. The passage of these amendments represents a culmination of the paradoxical journey begun at the nation's founding. Just as the original compromises had sought to balance competing interests through a written constitution, so too did these amendments attempt to reconcile the ideals of liberty and equality with the harsh realities of American life. Despite serving, fighting, and dying for a union that denied them civil and political rights, these men were not considered citizens under federal law. The U.S. Supreme Court's ruling in Dred Scott v. Sanford in 1857 held that African Americans, whether enslaved or free, could not be citizens under the Constitution. Your support helps us to reach more people with these important topics. Subscribe for more episodes and leave a comment below to share your thoughts on the legal aspects of the Civil War. Remember, you can also support us directly by becoming a member. Thank you again for watching, and I'll see you next time. Although this decision was effectively overturned after the war, it remained in effect throughout most of the conflict. This legal status highlights a significant paradox. African American men were permitted to risk their lives defending a nation that denied them fundamental rights. Their service underscores the hypocrisy and injustice of a system that celebrated liberty, perpetuating slavery and disenfranchisement. It was only after the war, following the passage of the 14th Amendment in 1868, that African Americans were legally recognized as citizens entitled to equal protection under the law. He stated that he had no purpose directly or indirectly to interfere with the institution of slavery in the states where it exists. One of the most pressing legal questions during the Civil War was whether states had the right to secede from the Union. The Constitution contains no explicit provision addressing secession. In the secession crisis of 1860–61, both sides interpreted this silence differently. Southern leaders argued that the absence of a prohibition on secession implied a state's right to leave the Union, allowing them to dissolve the federal compact. Union leaders, including Lincoln, countered that the Constitution created a perpetual union from which no state could unilaterally exit. This ambiguity led to a situation where secession was legal only in the sense that there was no legal mechanism to prevent it. But the legality of secession was never settled by legal means. it was decided by force on the battlefield. As historian Eric Foner notes, the Civil War itself was in essence a test case to settle the question of secession. The outcome, a resounding affirmation of national unity and the supremacy of the federal government, profoundly impacted the future trajectory of American constitutionalism. Instead, he argued for a return to the pre-secession constitutional order. This legal perspective reflects a deep commitment to the principles of federalism and constitutional restraint. Throughout the early years of the war, the Union made every effort to preserve the legal continuity of the conflict as a restoration of the constitutional order. This is reflected in the fact that for slaveholding border states Delaware, Maryland, Kentucky, and Missouri remained in the Union and slavery continued under state law. The Confederacy believed that each state retained sovereign authority to leave the Union and govern itself, even if that meant preserving an institution fundamentally incompatible with universal human rights. The order declared that enslaved people in states in rebellion were to be henceforth free. It's important to note that the proclamation didn't apply to slave states like Delaware or Maryland, which remained in the Union. The order focused on areas not under federal control. It's also the Emancipation Proclamation was not a legislative act and it did not abolish slavery nationwide. It was an exercise of military prerogative in designated areas. The legal significance of the proclamation lay in its alteration of the character of the war. It transformed the conflict into one aimed at ending slavery while maintaining the Union. As legal scholar Charles Fireman has argued, the proclamation exemplified the fusion of law and morality in Lincoln's approach to the presidency. It allowed him to take action where moral imperatives coincided with national interest, demonstrating that the ends of justice could be achieved within the bounds of constitutional authority. This led to what political scientist Eric Foner termed the contradictory logic of the Confederacy. The Confederate Constitution of 1861, while guaranteeing individual rights like speech, religion, and property, explicitly recognized and protected the right to own slaves. At the same time, the Confederacy was centralized enough to exert tight control over things such as conscription, taxation, and infrastructure, contradicting their rhetoric of decentralized governance. As legal scholar David M. O'Brien explains, the Confederacy was not really a confederation of states, as its name implied, but rather a centralized, highly authoritarian regime. This paradox was perhaps best captured in the secession crisis itself. When states like South Carolina left the Union, they did so legally speaking, through an act of self-determination, yet this act was based on a legal fiction. Secession was a contradiction in terms, a repudiation of a constitutional order based on principles of popular sovereignty and majority rule. So join me today as we explore the lesser-known legal aspects of this defining chapter in American history. Starting with the foundational paradox, liberty and legalized slavery. At the heart of the American legal system lies the principle of liberty. The Declaration of Independence of 1776 proclaims that all men are created equal, endowed with unalienable rights. However, this grand principle wasn't universally applied. And by 1860, approximately 4 million African Americans were enslaved. They were protected not just by custom or state law, but by codified statutes and state constitutions. The U.S. Constitution itself, though shunning the word slavery, sanctioned the institution through provisions such as the 3/5 compromise in Article I, Section 2, which counted enslaved people as 3/5 of a person for purposes of representation and taxation. The Fugitive Slave Clause in Article 4, Section 2, required the return of runaway enslaved people to their owners, and the delay of congressional prohibition on the slave trade prior to 1808 in Article 1, Section 9. These provisions show a legal framework that compromised liberty for the sake of union and political feasibility. Thus, the paradox is established. A republic built on liberty enshrined slavery as a constitutional and economic reality. As for how the war started, it was inevitable that this tension would come to a head. But now, let's move on to the Union's legal position and their initial reluctance to interfere with the institution of slavery. But all of that changed with the Emancipation Proclamation. On January 1st, 1863, President Lincoln issued the Emancipation Proclamation as a wartime executive order under his constitutional authority as Commander-in-Chief. However, The Emancipation Proclamation raised new legal questions, especially surrounding who could wield political power in newly emancipated territories. Next, let's turn to the legal question of the war itself and the paradox of constitutional silence. Finally, let's talk about the resolution of these paradoxes through the Reconstruction Amendments. Yet despite these legal advances, the true resolution of these constitutional paradoxes remains an ongoing process. Thank you for watching. If you enjoyed this episode, please consider liking it.